In the reference matter of construction of multi-storied buildings in forest lands Maharashtra, Supreme Court directed the chief secretaries of all the states and administrators of all the union territories to constitute special investigation teams for the purpose of examining as to whether any of the reserved forest land in the possession of revenue department has been allotted to any private individuals or institutions for any purpose other than the forestry purpose. The state governments and the union territories were also directed to take steps to take back the possession of the land from the persons or institutions in possession of such lands and hand over the same to the forest department. In case it is found that taking back the possession of the land would not be in the larger public interest, the state governments or union territories should recover the cost of the said land from the persons or institutions to whom they were allotted and use the said amount for the purpose of development of the forests. Court further directed the chief secretaries of all states and administrators of all the union territories to constitute special teams to ensure that all such transfers take place within a period of 1 year from today. Needless to state that hereinafter such land should be used only for the purpose of afforestation, said the court. In this matter, court held the allotment of 11.89 hectare of reserved forest land in survey number 21 Kondwa Budruk in district Pune for agriculture purposes on 28th August 1998 and subsequent permission given for its sale in favor of RRCHS on 30th October 1999 was totally illegal. It further held that environment clearance granted by MOEF on 3rd July 2007 to RRCHS is illegal and accordingly quashed and set aside. Since state of Maharashtra had recalled communication dated 4th August 1998 approving allotment of subject land to Chavan family, court said we uphold the same and it directed the possession of subject land which is reserved as a forest land but is in possession of the revenue department should be handed over to the forest department within a period of 3 months from today. Court noticed that such a vast stretch of land which is notified as forest land is still in possession of the revenue department. Such a situation creates many complexities as it is evident in the present matter. The revenue department, despite resistance from the forest department, allotted land to private individuals or institutions for non-forestry purposes. This in turn reduced vital green cover. Court therefore found that it is necessary that a direction needs to be issued to all state governments and union territories to hand over possession of lands which are recorded as forest land and which are in possession of the revenue department to forest department. The report of CEC would also reveal that there was material to show that many of forest lands had been allotted to private individuals or institutions for non-forestry purposes. Any such allotment after 12 December 1996, that is the date on which directions were given by Supreme Court in present proceedings, would not be sustainable in law. It would therefore be imperative that wherever it is possible to take back the possession of such land, the state or union territory should do so and hand over the possession to the forest department for forestry purposes. However, if on account of such lands being already converted for non-forest activities, it is found that taking back possession of the land would not be in larger public interest, then the states or union territories should recover the cost of land from such individuals or institutions and use the said amount for purpose of afforestation, restoration and conservation, said the court.